Thank you, everyone, for joining us for today's webinar, Conversion Therapy at the Court, Understanding Chiles v. Salazar. We now turn to our moderator for today's discussion, Alana Redfield, who is the Arnold D. Casoy Scholar of Law and Federal Policy Director here at the Williams Institute. Alana?
Hi, and thank you. Thanks for joining us today. My name's Alana, she, her pronouns, and I work at the Williams Institute. And we're here to talk about Chiles v. Salazar, the Supreme Court case regarding conversion therapy. There were oral arguments on October 7th, and we have a few experts here to talk about the case with us today. I'm joined by Dana Buskank from Cohen, Milstein, Sellers, and Toll, who is in the civil rights and employment practice, and they represented us when we submitted our brief in this case. I'm also joined by Dr. Elon Meyer, from the Williams Distinguished Senior Scholar of Public Policy at the Williams Institute, who was one of our amici in the case, and joined also by Craig Conniff, a full professor of law at the University of Virginia School of Law, who writes in health and civil rights as well as in health data regulation, and who also submitted a brief in this case. So I invite everyone to join, turn on their cameras and their microphones, and welcome. One last thing before we get started. If you do have a question, we will have time at the end, so please do put your questions in the Q&A feature of Zoom. So to start, I think it's helpful to get a sense for what this case is about, starting with the meaning of the term conversion therapy. Now, I should note that for some of us, when we received the email promoting this event, it said, join us for conversion therapy today. And just want to note that that was just a quick email formatting thing, but we're actually here to talk about the meaning of conversion therapy and the really harmful impacts that have been documented through research, as well as how the court is going to approach it in the future. So I'm going to start by asking Dr. Meyer to tell us a little bit about what we mean when we say conversion therapy.
Thank you, Lana, and hello, everybody. I'm glad to be here. This is such an important topic, has been for so long. The first thing I would say about conversion therapy, that it's not real therapy, because when you say therapy, you have the connotation that something that's helpful, that is supportive, that is leading to positive results. And with so-called conversion therapy, which we refer to as sexual orientation and gender identity change effort, which is the effort to change those, we don't, it is not an approved therapy by any reputable mental health organization. It is not a therapy that is taught in any school. It is, moreover, a therapy that is not allowed by many of the professional organizations like the American Psychological Association, the Social Work, the American Medical Association, literally every reputable organization. Despite that, um, it is a form of treatment that is practiced in the United States and across the world. It has a very long history of being practiced, including many approaches to this so-called therapy that were um, aversive techniques, that is, like anything ranging from applying some kind of shock therapy to providing other types of negative reinforcements. I won't get into them, but one of my favorite is the rubber band technique, which the patient was asked to pinch themselves with a rubber band on their wrist every time they see a positive, attractive person or somebody they're attracted to, a same-sex person. So it was things like that, leading all the way to what we call sometimes talk therapy, which is just talking about things, with a very huge component of religious counseling and religious praying and things like that. So there's a huge range of what conversion therapy is. I'll tell you one finding from our study that we did a few years ago. We looked at 3 generations of lesbian, gay, bisexual people and asked them about the exposure to conversion therapy. And the purpose of the study was to see how changes in the social and legal arena, more positive changes, affected the lives of LGBT people. We also have a transgender study that I'll talk about in a minute. But what the shocking part was that older people who grew up in the 50s and 60s did not differ from younger people who grew up in the 2000s in terms of their exposure to conversion therapy. So it is not something that has died down in any way. Among transgender people, as I said, we have two different studies. One of them is called TransPop, and the proportion of people who said they were exposed to gender identity change effort were close to 20%. In another study, the USTS study, it's about 13 or 14%. So a huge number of people who are exposed to these therapies. And do you want, maybe we'll move on. I did want to talk about this particular case, but I'm sure we'll get to that in a second.
Well, actually, if you want to say a little bit about the facts of the case, I think it's a good time to bring that in.
Yeah, so this case was both brought by Kaylee Chiles. She has a mental health degree, a Masters of Arts degree in clinical mental health, a field that I've never heard of, as well as in religious studies. And she was represented by very right-wing organization, ADF, Alliance Defending Freedom, that have led a lot of those anti-LGBT cases that were brought to the court and other to the Supreme Court and other courts. And she claims that she's a licensed therapist in Colorado, and she sued Colorado to say that her rights to express her religion and her free speech right generally were infringed upon by having this law that bans her from providing conversion therapy. And I just want to say two things that I have annoyed me in the coverage that people ignored, it seemed. Not that it's a secret, not that nobody knows about it, but I think it's very central. Number one, the law bans conversion therapy for youth only. Any adult who has a free will to go and seek for that can go to a licensed therapist that professes to do this, and they can choose to do that. The other thing, the law only applies to licensed therapists. Ms. Childs could very easily give up her license, open a shop, and provide religious conversion therapy to anybody who wants to come to her. But she can't do, according to the current law, is get a license, a stamp of approval from the state that says that she's practicing therapy according to the state-of-the-art standards, and also not provide state-of-the-art treatment. So that is what the law says. And that is what she doesn't agree with, because she wants to both get the license and also provide therapy that is not approved by any organization. I would also add that, of course, religious organizations are completely not included in this law. They can do anything they want, and they do, in fact, provide a lot of the conversion therapies that happen in the US are done through religious organizations. They're not impacted by this law. So it's a quite narrow law for youth, from licensed therapists, and in my reading of her claim, I was really amazed that she can make such a claim, because she doesn't have to be licensed if she doesn't want to, or she can be licensed and abide by the rules that mental health organizations have put forward regarding the standards of treatment.
So actually, that's a great time for me to bring in Dana here. Dana, you want to talk a little bit about the claims that were made by each side?
Sure, yeah, and thank you to the Williams Institute for hosting this and for being such great partners in our filing our amicus brief. I wanted to tag on to something that Dr. Meyer mentioned, which I think is important context for who brought this case, and the Alliance Defending Freedom, the ADF, which is a conservative Christian legal advocacy group that strategically brings litigation to further an anti-LGBTQ agenda and also an anti-abortion agenda. And they're behind some of the Supreme Court's kind of latest and least great hits, such as the Dobbs decision overturning the right to abortion and the 303 creative decision, another case out of Colorado about the website designers who refused to make a website for a gay wedding. They also actually brought an extremely similar case to the Supreme Court 2 years ago called Tingley versus Ferguson, which was challenging Washington state's law prohibiting the practice of conversion therapy using basically the same arguments. And at the time, the court declined to hear the case, so we didn't reach the decision. And so 2 years later, here we are, them kind of furthering this agenda. And so with that context in mind, Kaylee Chiles and the ADF framed their argument that Colorado's law prohibiting the practice of conversion therapy on minors is an unconstitutional restriction on free speech, specifically because it is a viewpoint-based restriction on speech. And so there's kind of two important elements of that. One is the fact of them arguing that talk therapy is speech just because it involves the act of talking, which triggers First Amendment protections. And then the second part is that framing this as a viewpoint-based restriction, in that if a counselor who wanted to encourage someone to explore and embrace their LGBTQ identity, they would be fine under this law, but the inverse would not be. And therefore, it's based on viewpoint. And as one of Ms. Chiles' attorneys framed it, that it would be akin to transforming counselors into the mouthpieces for the government to further their ideologies. And both of these elements are really important in getting to the end goal that Ms. Chiles and the ADF want, which is for the court to apply the highest level of review of strict scrutiny and for the court to find that Colorado can't meet that burden of showing that this is a legitimate law that protects interests. Importantly, to me at least, the way that Chiles is framing this argument around that really highlights that this is part of their ideological strategy. They relied on anonymous Reddit posts to claim that there were children in Colorado seeking conversion therapy, and that the harm from this law comes from not allowing those anonymous Reddit posters to get that therapy, as well as harm to Ms. Chiles for not being allowed to practice this type of therapy, even though neither she nor anyone else have ever been disciplined under this law, and it's been on the books for several years. And that's kind of a whole separate issue that the court unfortunately did not decide to really take up. Colorado, on the other hand, really focuses on who this law actually impacts, which is the youth in Colorado who might be subject to a harmful and ineffective practice. And this is Colorado's right as a state to protect their most vulnerable citizens. And so they really focus on the medical treatment aspect of talk therapy, because the part of talk therapy is a medical treatment. It's not just a conversation between friends or even a conversation between a counselor and a client outside of the medical treatment context. And therefore, this talk therapy qualifies as speech incidental to conduct, the conduct being the medical treatment, which has a much lower standard of review for First Amendment violations. And as Dr. Meyer was flagging, for Colorado, the important part here is that this law only applies to licensed professionals, and that is professionals that can lean on the legitimacy and the blessing of the state to provide care, which inevitably, of course, creates a power imbalance between the practitioner and their patient, and allows them to kind of say, have the backing of the state behind them, excuse me. And that's something that Colorado as a state wants to be able to regulate. And as Colorado points out, the court has a long history of allowing states to protect their citizens from substandard medical care by offering these same types of regulations and trusting the state to make these decisions based on evidence for what the standard of care is. And that's also very important because there's 20 other states who also have very, very similar laws to this one.
Thank you. And actually, it's a great time to pull in our law professor, Professor Conniff. Could you help our audience, particularly those who aren't lawyers, understand some of these big doctrinal questions that Dana just brought up there?
Yeah, no, absolutely. Well, I just wanted to first just go back to the facts for a second. So before I went to academia, I was California's Deputy Solicitor General, and California passed the first such law and then faced the first such challenge, the case is Pickup versus Brown. This was, and it wasn't brought by ADF, it was brought by North and a couple of other groups that had long been involved in the conversion therapy business, or conversion efforts business, I should say. And and so one thing that I want to mention is that, as we said in California, and I believe the Colorado Attorney General has also said, not only are, can a child perform the therapy if she gives up a license, but she can do so in a different capacity. So let's say, she's a minister at a church as well as a therapist. She can say, look, I can't do this in my capacity as a licensed therapist, but I can do this as a minister, right? The only thing she can't do is then bill insurance. And she wants to get paid for her services, I assume, and wants to bill insurance for the services. So really, to a large degree, this case is not just about asserting religious freedom and various other sometimes laudable goals, but it's seeking to get insurance money for performing these services on children, right? So that's partially what the case boils down to. So let's take a step back. And, one of the big questions here is there speech involved, right? And if there is speech involved, what level of scrutiny applies? There is no question the Colorado Solicitor General conceded that if this is speech, it is viewpoint discriminatory, right? So the real question really is whether there is a speech involved and whether there's some carve out to speech. Now, the medical speech precedent goes back several years. The first relevant case is Planned Parenthood versus Casey, which some of us may remember from law school, which is the first major revisiting of Roe versus Wade that the Supreme Court did. And at issue in that case was, among other provisions, a law in Pennsylvania that required abortion providers, to give to women a whole list of information regarding abortion, and some providers didn't want to do it. And they said, look, this mandated disclosure violates our free speech rights. And the Supreme Court said, well, yeah, but in a professional context, you can be required to provide such information. Now, fast forward with a few other wrinkles and a couple of other important cases, but to 2018, where the Supreme Court comes down with another case this time involving crisis pregnancy centers. Now, crisis pregnancy centers are usually religiously affiliated healthcare centers that seek to provide pregnancy care for women. And this time, California had passed a law saying, look, if a woman comes to you seeking care, you've got to let them know that they have access to free or low-cost services from the state of California Medicaid, including abortion. And they thought that they were protected under Casey. Casey says you can be required to provide such information in medical contexts. And they said, well, so should we. And the Supreme Court said, no, in this case, this mandated disclosure does violate the free speech rights of the crisis pregnancy centers, because in Casey, the speech that was regulated was incident to conduct. It was incident to some kind of medical procedure. And in this case, there is no medical procedure to which the speech is incident, right? And so, in other words, abortions and so on, procedure, so any speech surrounding the procedure, including informed consent, I'm just emphasizing this because it's so important, that can be regulated and mandated by the state. But when there is no procedure involved, then the speech, and only speech is involved, then that becomes a problem. And the regulation of such speech becomes a problem. Now, the court offers a couple of other exceptions that aren't relevant here. It does say that the regulation of medical malpractice law is something that it has long been recognized in the nation's history, and suggests that that would not be subject to full First Amendment scrutiny and not be treated to the kinds of scrutiny that the plaintiff seeks here. Now we come to this case. Now, in this case, the 10th Circuit basically held that the treatment at issue did not fall on the speech side of the line. It fell on the conduct side of the line, because at the end of the day, you are providing some kind of activity. It's treatment, right? You're not expressing your views. Now, what's interesting is that the Colorado Solicitor General had a dilemma. I sat through a couple of the moots. And and the dilemma was, and I don't think this is confidential because it's a fairly apparent dilemma. One is you defend the 10th Circuit rule and say this is conduct, or maybe and in the alternative, you basically say, look, let's go back to the Crisis Pregnancy Center case, NIFLA, the National Institute of Family and Life Advocates versus Becerra. So let's go back to NIFLA. There you said medical malpractice laws are insulated. They aren't subject to the usual First Amendment rule. But we should expand this generally to thinking about standard of care laws. What is good medical treatment? And sometimes good medical treatment involves giving some kind of advice, but not other kind of advice, whether or not a procedure is involved. And doctors often give advice without providing any procedure. And we want to hold that advice to some kind of standard, right? And so what Colorado also argued was, even if this is speech, when it comes to standard of care regulation, when you're trying to regulate a medical standard of care, then you cannot subject this to First Amendment scrutiny, because then you have courts basically trying to decide what the medical standard of care is and should be. So that was essentially the argument, the two sets of arguments that the Colorado Attorney General tried to advance. One is, this is arguably conduct. And then also that if this is speech, then this is speech involving the standard of care. There are plenty of cases in precedent that when the standard of care is involved, when doctors give bad and shoddy advice, they are subject to medical malpractice suits. And so any standard of care law should be insulated from First Amendment scrutiny.
Let's actually turn to that standard of care question. So there are sort of a formal sense for what the standard of care is, and is the state following it, but there's also this question about, in general, what do we know about conversion therapy, and what does the research show? What does the evidence show about conversion therapy? And I found it striking in the oral arguments that there was this sort of refrain that the state had not cited a single study that was relevant to the question at issue. So just to help understand that a little bit more, I'm going to turn to Alon for a second. What does the evidence actually say about conversion therapy?
Yeah, and going for a minute to the end, which was the oral argument, there were really interesting issues raised around evidence and quality of evidence, and really whether we can trust experts anymore. It was a little scary to me to hear some of the argument of ADF. But let's start with what we do know. I'll start by saying there's never been a clinical trial that randomized a group of people to provide them with conversion therapy and another group of people who got an alternative therapy. And then, I don't know, a year or 2 years later, we tested them to see who is doing better. There has not been such a thing because it would be unethical, number one, and nobody would do it. Nobody would take some LGBT kids and say, here, we're going to convert you to becoming straight and cisgender. So that has not happened. Short of that, we have numerous studies and have had numerous studies that showed two things pretty clearly. The first thing that they showed was that conversion therapy, and we're going to use the term conversion therapy, despite the connotations that I don't like, conversion therapy does not actually succeed in converting LGBT people to become straight and cisgender. So that's number one. I know there's been some states, I believe in New Jersey, that they were sued around commerce issues, that they're promising something that is just not good product. Which I do like. So number one, there is no evidence that it actually helps anybody who genuinely wants to change their sexual orientation and gender identity. Number two, we do have a lot of studies using different methodologies, including quantitative and qualitative studies, including studies that use population-based representative samples and non-representative or non-probability samples. The overwhelming majority of these studies showed that there is a negative effect or a potential for a negative effect. And I have to be careful here because, as I said, the clinical trial will be the standard test of the effect of a therapy. Just like when you do a drug test, you have to use a clinical trial to be able to say this drug is better than that drug. We don't have that. But what we do have is a lot of, I would say, maybe we can call it in this context, circumstantial evidence, studies that looked at people. So, for example, our own study, we looked at people who had conversion therapy, and we looked at rates of suicide ideation and suicide attempts in the population and compared the ones with and without conversion therapy. And we find that those who had conversion therapy in their past were more likely to have suicidal ideation and suicide attempts. That is not a foolproof, but it is suggestive of a negative effect. Now, there's been many, many studies that shows things like that, whether they looked at suicide ideation, suicide attempts, depression, anxiety, as well as some other more general outcomes. There were two studies that we cited that the oral argument actually brought up, one by Amy Green and one by Jack Turban, that looked at youth who had undergone this therapy and showed the same thing, that there are negative effects leading to um, suicidal ideation, suicide attempts. About 2 times more than people or LGBT people who didn't have this exposure to conversion therapy. So overall, if you have to use the evidence that we have, you have to say it doesn't help even people who want it, and it potentially could be very harmful. It doesn't mean that everybody who went to conversion therapy attempted suicide, but that idea that there's a connection is already suggesting that it's a bad idea to engage in conversion therapy, and that it justifies why so many professional organizations have come against it, specifically stating that conversion therapy should not be practiced with LGBT people. Now, I don't know if you want to get to their demands. I just would say that in the oral arguments, the lawyer for ADF suggested that there is no studies because in his understanding, the studies would have to be so specific. So first of all, one thing that they kept saying, well, those studies are talk therapy, and we're not talking about the aversive technique that I mentioned before, like shock therapy. Those have not been practiced for a long time, and most of the studies would not have included those aversive tests. And most of the studies that we have that I mentioned just now, the people who practiced, who were exposed to conversion therapy, were exposed to talk therapy, mostly, perhaps with some other elements like religious praying and things like that. But they were not so different than what is practiced today, the way that the ADF lawyer was trying to portray them. The other thing that he demanded is a study that basically looks at the kind of therapy that this particular therapist is doing. And we're never going to have something like that. We do studies on a population basis. They didn't all get the same therapy. And in fact, the fact that we're showing this negative results in what was practiced in so many different ways by so many practitioners, and we're still seeing an effect, suggests that there is a strong effect behind it. In other words, the distributing the types of therapies and the type of providers and the professional background of those providers would completely erase any kind of effect if it was all kind of random. Um, but no study has studied specifically what a master's in mental clinical health, as Chiles is, has done specifically for her practice of conversion therapy, which they don't even specify what it is. So the idea that we can come up with any evidence that would convince the ADF seems to be it seems to be an impossible type of test that they are asking for. And the last thing I would say, there was one study that the ADF brief did quote. They only quoted one study of the effect of conversion therapy. That study was done by Paul Solis, who is a retired Catholic University professor who is now a researcher at the Ruth Institute. And this study happened to be using our own data. And the study conclusions was somewhat difficult to follow, but using 7 stages of analysis that he did, he finally concluded that they're actually beneficial. And we and many other people have written to the journal and published reports showing why his logic was flawed and why he could not show what he showed. But that was the only study that the ADF actually quoted. We did, finally, we did a review of 13 studies that have been published since 2013, 2000. And was it 2000, 2020? And we showed that the only study that showed that was this Catholic University professor, and that was the one study that everybody agrees was flawed.
Thank
Sorry.
you. Yeah, thank you. And so I want to bring in Craig and Dana now, just in case you have thoughts on this question of the evidence and how the court discussed it. I'll start with you, Craig.
Yeah, so three quick points. The first is that I felt this was a moment where the oral argument faltered because the court pressed the Colorado Solicitor General on when they should give deference to the state. So they said, well, should we give deference when there are different schools of thought? And so what if we believe the evidence here is that maybe it's not quite clear what the standard of care should be. And I won't go into her answer, but to my mind, it's a question that puts the cart before the horse, right? Because if you're giving deference to the state because they've got good evidence, then you aren't giving deference to the state. They've already met the evidentiary standard, right? And if you aren't giving deference to the state because they don't have the evidence, so that puts the cart before the horse. The question is, if this is, so you've got to keep the speech question, right front and center, right, and sort of try and persuade the court that standard of care is a carve out here. But going to the evidentiary point, these issues have plagued civil rights litigation since Brown versus Board of Education and before, right? So in Brown, the question was, well, you've not proved that kids experience stigma if it's state versus private discrimination, because there are some private schools in the study, right? Okay, well, you've not proved that this is true of the particular grade in which the student is, right? So you can keep slicing and dicing the evidentiary demand to get to the level of precision, at which point you can't even generalize anything anymore, right? And I think that that's what ADF is trying to do here, right? Oh well, this is you're talking about therapies where the child, it's unclear whether the child has gone involuntarily, and so therefore you can't extrapolate from that. Well, when you're talking about children under 10, what does voluntary even mean, right? So many of the evidentiary demands that ADF was placing made no sense. The other aspect is that just ethically, you can't do this, right? So I teach health law. There is no IRB in this country that would say you can have a randomized trial where you subject some children to what existing evidence shows is harmful, right? There isn't an IRB that would allow this, right? So in these situations, courts all the time say, yeah, this is just common knowledge. The court talked about this at oral argument. Yeah, it's common knowledge. If a therapist says, look, you've got to engage in self-harming behavior, well, it's common knowledge. You can't do that, right? So really, this comes down to the values that the court is trying to impose on us. Is being gay harmful or not, right? And there clearly is this underlying thread in the oral argument that actually being gay could be harmful and should be cured. And I think that is an assumption that we're facing in this case.
And being trans. There's a lot in there.
Oh yes, of course, exactly, and gender identity.
Yeah, it played a pretty large role in, strangely.
Yeah, exactly. I mean, and I want to talk about that, but I won't talk about that now. And you turn it over to Dana. Yeah.
Yeah, we're gonna come to that in just a second. So, Dana, do you want to talk any reactions to the evidence part?
I just think very, very briefly, I think for, at the argument, I think maybe the only slight glimmer of hope of this law not being found unconstitutional at this moment is that Justices Jackson and Sotomayor in particular push the potential of pushing this evidentiary question back down to the lower courts because the Supreme Court is not a weigher of evidence, it's not a trial court. So instead of finding that this law cannot satisfy strict scrutiny, they would just find that strict scrutiny applies and kick it back down to the trial court, which pushes off that decision for a little while longer. I don't know, Justice Barrett seemed to bite on that a little bit. I don't know how likely that is to happen, but that was just something that I was thinking about.
Yeah,
I mean, I just want to say that they aren't going to do that. This court will not do it. Though I agree with you, Dana, that's the correct thing for them to do. But yeah.
So then let's turn to the standards of care. And to do that, I do want to bring back the Supreme Court's recent decision in the Scarametti case. So there's this question of whether and how the state can regulate medical treatments. And that had a big splashy case regarding gender-affirming care that was decided this past June. So Dana, do you want to tell us a little about Scarametti and how it relates?
Yeah, sure. So, Scarametti was in a different kind of doctrinal area of First Amendment. It was an equal protection claim. And I think that, the argument here and the opinion in Scarametti, to me, are really clear about examples of how this court is just kind of breaking from both tradition and logic to reach, outcomes that they desire, even if it creates really conflicting law and confusing law. So in Scarametti, the court emphasized the rights of states to basically be able to inflict harm on LGBTQ minors by upholding Tennessee's law banning gender-affirming care for minors. Scarametti contained a lot of twisted logic. I could go on about it for a long time, but when you compare it here with arguments here, it's almost even more twisted because the court there used medical uncertainty to allow Tennessee to decide trans kids, should not be allowed access to this care because we're going to trust the state here that Tennessee made this decision. Whereas here, they're using that same medical uncertainty to challenge Colorado's decision to protect minors and not to trust Colorado's judgment. Justice Jackson kind of brought this up during the argument, asking the government's lawyer, who's arguing on the same side as Chiles. And he didn't really have a good response, basically responding that the law at issue in Scarametti was regulating on the basis of age and gender, but it really doesn't provide any justification for why different reasoning should apply in both these places. And it creates really confusing precedent and law because, trial courts and district courts have been complaining that law coming down from the Supreme Court recently is hard to follow. They don't know how to implement it. And it's because a lot of these really conflicting, rulings coming out from the court. So, Scarametti was slightly different, but it shows really that this court is very outcome determinative and will kind of twist things to get to the solution that they want to get to.
Craig, did you want to jump in?
Yeah, absolutely. So as you know, I filed in Scarametti as well, and worked on the case for a little while. And again, I think I've got 3 points. The first is to pick up on what Dana said. In Scarametti, there is a portion of the opinion. They begin the opinion by saying, when a reference to sex is made, possibly in a medical context, then that does not necessarily invite strict scrutiny because as a medical matter, there are differences between the sexes, biological differences between the sexes, and they cite to some random FDA guidance, right? I mean, it's just, I just want to point that out instead of relevant Supreme Court case law, because the relevant Supreme Court case law does not say that. Right? So they cite to some random FDA guidance to say that in a medical context, we don't really apply strict scrutiny in this way. And so there is this inconsistency between Scarametti and the way they handle the issues in this case, because apparently in medical context here, when it comes to standard of care, they've got no issue moving forward, because I do think that that's the writing on the wall that they're going to apply strict scrutiny here. The second point, though, is that that this is a problem for us as well, right? Are we being hypocritical by taking one stand in Scarametti, right, and saying that the state regulation there is wrong, and taking a different stand here and saying that the state regulation is right? And I don't think that that's the case, because I don't believe that medical deference automatically applies in every situation, right? I do believe, so Scarametti was a sex discrimination case. And the question was whether the statute discriminated based on sex. And the statute mentioned sex 7 times. It mentioned a diagnosis one time. The Supreme Court ignored the 7 times the statute classified based on diagnosis and said, discriminated based on sex on its face, and only referred to the one time when it discriminated based on diagnosis and said, this is a diagnosis discrimination case. That's not a sex discrimination case. So these textualists didn't read the text of the statute or ignored the text of the statute. That's fine. But it's not fine, but nothing we can do about it. But the point
But
is
it happened.
that's the way we should distinguish Scrimeti away, right? In Scrimeti, there was clear sex discrimination. In this case, even if I personally believe that the First Amendment is meant to protect expression. And when you're a doctor, you're not expressing your whatever artistic, whatever side when you're performing treatment. You are acting as a professional conduit, translating professional information that you studied to the patient, even if you don't agree with it and you have some crackpot theory that the profession doesn't recognize. That would be medical malpractice, right? So that's not expression. But even if you believe it's expressive and protected by the First Amendment, history and tradition, which this court purports to rely on, says that this should not be subject to First Amendment scrutiny, right? So I think that Scrimeti can be distinguished away, which is that in the First Amendment context, the rules, there is this kind of medical deference. When it comes to sex discrimination, there isn't and there shouldn't be. The third thing I want to make is, to get to, as we talked about earlier, is the relationship with trans rights. So basically, when it comes to conversion therapy doesn't have as much purchase in the conservative movement as trans rights do, right? I mean, just as the boogeyman that people purport to be afraid of. And so they really tried very hard to make this case about trans rights. If you read the briefs, they basically lie. I'm sorry, there's just no other way to put it, and say that actually, with this law on the books, mental health care will not be provided to minors who have gender dysphoria, right? Or who may have gender dysphoria, which is completely bizarre because to have a diagnosis of gender dysphoria, you need mental health care, right? So, and so basically they suggested, they say this at various points, they don't suggest it, they say it, which is that with this law on the books, the only treatment that will be open to minors is hormone therapy and puberty blockers, right? So they completely misrepresent what's happening, but that's the boogeyman they feed the court, right? Because gayness, Justice Kavanaugh and Justice Gorsuch, they pretend to be okay with gay people and so on, right? But when it comes to trans people, they really aren't okay with trans people, right? And they don't purport to be okay with trans people, I think, and so trans people are very much painted as the boogeyman. The forcible, creation of trans people is the fear that the plaintiff in Chiles, I think, seeks to instill in the court.
Yeah, and yes, go ahead.
I just want to say something about the standard of care that has been really disturbing to me. I think in both those cases, by the way, there is a majority opinion that supports the care of transgender people, such as described by the W path. There's a majority opinion that supports banning conversion therapy, such as the APA, the AMA, and many other organizations. And then there's what I would call fringe organizations or minority reports, such as the CAS report. And in each case, the CAS report, which suggested that there's harm in providing care for young transgender people. And in each case, it seems like the court is choosing to either rely on the fringe report rather than the majority report. So WPATH, which establishes the standards of care for transgender people for the past 40 years, has been completely put aside because they chose to believe whatever they choose to believe. In the conversion therapy, same thing. They are choosing to ignore the most major American, and not just American, but we're in the United States here, mental health organizations, medical organizations, and instead quote, as I said before, the one study that showed something that they liked. And I think for the court, it is concerning that judges usually feel overwhelmed when they have data from both sides and they throw their hands in the air and say, we can't judge this. This expert says this expert says that. And therefore, we're not going to listen to any expert. And I think that to me is a very dangerous development. And I just want to say this is not a coincidence that we're here. The conservative groups, the Christian right groups that are fighting LGBT rights, have been working on this for several decades to establish an alternative system of opinions and establish their experts. I feel like it all started with Proposition 8 when they were caught completely empty handed. They were called to a trial on the Proposition 8 in California, and they didn't have experts that would support any of the rhetoric. And since then, they have been slowly establishing organizations, establishing a group that look like they're professional groups, even though there might be a very tiny representation of the professionals involved, and also creating a record in scientific journals. That record is not always the most rigorous or the most prestigious journals, but they do so in a very methodical way, such as by writing a letter to a prestigious journal and then quoting the letter that they wrote, which letters, of course, are not as rigorously reviewed. Um, so that is a great concern to me that we're losing the authority of experts. And by expert, I don't just mean us here in this call, but the major professional organizations in the United States that have always provided what does it mean to have a standard of care? And it doesn't mean that standard of care don't change, by the way. The court asked this question, well, what if they change? If they change, we will change the treatment. The same thing happens with medications. Like sometimes we have medications and then we find a better one, or we find that the one we used was actually not good. That does happen. Professional organizations can change the standard of care. But the question in my mind is, um, are we going to listen to professionals and experts?
I want to clarify the record. You said majority opinion, and I think what you're referring to is a near consensus of experts, right? When you said majority opinion, not a Supreme
Yeah,
Court.
I didn't mean, yeah.
Um, and and I want
And
to bring in one other thing before I turn it over to Craig and Dana, is the comment from Justice Alito that was making a kind of moral outrage argument about, well, we have to intervene in these egregious cases, and referring back to Buck v. Bell, which had to do with state-sanctioned sterilization. And and so this idea that you need to that the court, well, what's the line, and when should the court take the stand, like what is the place where the standard of care, does cross the line, and how do you decide it? I think that way that it was framed in the argument was a little bit shocking. So anyway, I'll hand over to you, Craig. I know you had a comment, but I'm curious what you think of those developments.
Yeah, I mean, so just picking up on what Ilan said, and then I had both these comments. That's great. So there were briefs that basically said the AMA, both the APAs, are captured by woke liberals. They not quite put that way, but that's basically what they said, right? So you need to disregard their authority, and you need to look at these fringe organizations. Um, but a little note on history. So, this kind of medical activism in its modern form started at least in the 1980s when Everett Koop was asked, who was the Surgeon General at the time, was asked to basically, under Reagan, was asked to basically certify abortion trauma syndrome as or post-abortion syndrome, depending on what you want to call it, as a major health concern to fight against Roe versus Wade. But the fact is that medicine has historically not been very nice towards minorities, because what Koop was doing and what Koop was asked to do, he ended up not doing it, goes back to Freudian theories, which in turn go back to even older theories regarding how women's nervous energy and their reproductive capacities and the like. LGBT people haven't been treated well by medicine, and that was referred to in oral argument as well. In the constellation of Sam Alito's offensive comments, and it's a vast constellation. I don't actually think of this as terribly offensive because, I mean, maybe I've just become desensitized, but medicine has historically been bad, right? The question then becomes, can we distinguish this? And the answer, again, as when I was talking about Scrimeti, we can distinguish away Scrimeti. We can distinguish away Buck versus Bell, right? When there is a vulnerable group that is being targeted, right, that has historically always invited a higher level of scrutiny, at least in modern jurisprudence, and we should continue doing so, right? Whether it's Scrimeti versus whether it's Buck versus Bell. The final little footnote is that diagnosis discrimination is also problematic. The court sort of blithely moves past that in Scrimeti, and I know that this webinar is not about Scrimeti, but I think that is important to keep in mind.
Thank you. Any thoughts on this, Dana, before we move on?
I just couldn't help but thinking during the argument about kind of also the political context of the moment that we're in, and thinking about a future where we've seen this administration kind of make up or just state that they're going to find evidence to support whatever they're doing, and thinking about how the court felt to me like they were previewing how they're going to be relying on this administration's creation of evidence to further their goals, and so that was just a little scary to me to think about.
Yeah, so then actually it's a great transition to my last kind of question, which also is related to some of the great Q&A we've gotten from the audience, but I don't want to say any foregone conclusions, but I do feel skeptical myself about a particularly favorable outcome here. However, I'd love to hear your thoughts from the panel about how you think this might go. And then also, as one of our audience members asked, what does this mean for the future? Like, how are we going to protect LGBTQ youth and adults if this particular type of legal remedy is no longer available? Start with Dana. Do you want to start?
Maybe I'm still gathering my thoughts on that question. If someone else has something to,
Well,
I'll break it into two parts. The first part is, where do
one-
you think this case is going? And then we'll come back to the second part. And
Yeah.
I'll go with, yeah, Ilan, you want to jump in?
Well, I was
Elon.
going to go with the second part, which is, I mean, I think where the case is going, I don't want to say it, but it doesn't look great. But I think the remedy, in my mind, and how we protect LGBT people in the future is by increasing knowledge of the public about the harms of conversion therapy. I think a lot of the people who seek conversion therapy are parents in this case, or maybe the children themselves, but with the parents' permission. I think a lot of them want the best for the children, and I think they don't know the damage of conversion therapy and well, the fact that it doesn't actually convert anybody. Uh, and I would just say we had once at the Williams Institute a mother of a transgender 5-year-old child, and she told us how important our website was for her to learn about the importance of accepting your child's gender identity. And her husband was a firefighter who had a lot of difficulties, and she said she was able to convince him by showing him data. And I think the same thing, and again, maybe that's I'm saying it because that's our mission is to disseminate data and to do this work to show the provide evidence. But I think if more parents and people knew of the damage rather than the empty promises that they get, that could help prevent exposure to in the future.
Thank you. Craig, did you want to go next?
Yeah. So first prediction. The prediction is I think the court is going to say that this is speech, that it's subject to strict scrutiny. It's going to say that medical malpractice suits can still proceed, but that medical malpractice has procedural requirements that are higher than what we have here, though that's not quite true. I will also note that at oral argument, the lawyer on the other side said that there may be some medical malpractice cases where the doctor can make a free speech defense and say, no, this is within my rights of free speech. So I think, and I think they're going to say that the law is invalid. Now, I I want to add in terms of long-term effects. I mean, I hope Ilan is right. One of the problems is that the Williams Institute reports it would be illegal to distribute them in many schools, right? And I think that this is a very concerted. I was talking to the brilliant Jenny Pizer over at Lambda Legal, and she pointed out, she drew this argument that this is essentially, a way to further denigrate LGBT people, LGBT identity, right? And so if you think about the Don't Say Gay books ban, Mahmoud versus Taylor, which is a case from last term, as prevent the children from learning about homosexuality and trans identity. So that's at the front end, and then this is at the back end. And if they slip through, then you get to convert them back, right? And I think that this is part of a much broader fight that where we need to build alliances to try and address the harms that are being caused across the board, not just in LGBT rights, but with respect to other minority groups as well.
Thank you. And Dana?
Yeah, I'll just add that I had the pleasure recently of being at an event hosted by Advocates for Trans Equality, which is a organization that does legal advocacy for trans rights, and heard their fantastic executive director Annie Murrah speak. And in a room full of trans people in a legal setting, in this instance, it's sometimes a little scary, but she offered just some really powerful words about our communities have been here before, and these fights have been going on for a long time, and we have each other and the people in this room, and the people you have to look to, the people who are fighting this, and have a little. It's hard, but sometimes have a little radical optimism. And also, one thing she emphasizes is that it may be a really tough path in the courts right now, but there's a lot of advocacy going on state levels and local levels as well. And this is really a time to kind of join together with your community and with the people that your neighbors and your friends and your family, to be able to continue advocating for the rights that you care about.
Here.
Okay, any closing thoughts before we wrap up? Thank you to our audience for your great questions. I think we covered most of them. Any questions, any last comments from our panelists before we wrap up?
I think Dana said it best, actually. I think that's a great point.
Excellent. So we'll end here. Thank you all, and have a wonderful day.
Thank you. Right.
Thank you, Alana.